Well, hello everybody, all you aspiring lawyers, all you practitioners, and all of those that are interested in arbitration. I have got good news for you today. Today we are in the presence of a legend, not a legend in the making, but a legend indeed. Ladies and gentlemen, please help me welcome Michael Kuper, Senior Counsel. Michael, welcome to the show.
Thank you so much. Lovely to be here.
Absolutely. Thank you so much, Michael, again, for joining us here. Now, before we read a bit about your profile here, because it's quite lengthy, who is Michael Kuper?
Well, he's a fairly old advocate and has spent a lot of his professional life in arbitration and in work associated with arbitration. And otherwise, a proud father, a proud grandfather, and a more proud great-grandfather.
That's right, you heard it here. Now, if we go to Michael Kuper's profile, I'm telling you, we're reading out the thesis here, but perhaps for the purposes of what we're doing here today, the chairman of the Arbitration Foundation of Southern Africa, AFSA, as is commonly known, very well known, and China-Africa Joint Arbitration Center, acronym known as KJAC. Michael has traveled extensively, as he's already mentioned, doing the work of arbitrations. Now, some of you might be saying, what is arbitration? And that's what we're going to get into just a little bit. But before we do that, Michael, a little bit about what you enjoy doing in your spare time other than solving people's disputes.
Well, I read a lot. I research matters particularly of history that interest me, and I walk my dogs.
Oh yes, dogs. They can be a problem child for some. What breed do you have?
Jack Russell.
Jack Russell. And I believe you said you have 6 of those.
I do indeed.
A father and a grandfather and a great-grandfather.
Yes. Yes.
So you were telling me a little earlier that the secrets of
yes. Yes. The great lesson to learn, and I give it to you free of charge, is that sons are useless. If you have a son, try again. What you need is to marry young and have a daughter. And your daughter needs to marry young and have a daughter. And if you get all that right, then you've got a chance of seeing your great-grandchildren.
The secrets of life here given free of charge. Obviously, Advocate Michael Kuper saying he won't be sending you an invoice, which we know can be quite hefty with these years of experience. But we'll ask you some personal stuff later. Let's jump straight into the hard stuff today. You're certainly one of the most recognized, if not the most recognized figures. Certainly South Africa, Southern Africa, and possibly African parts of the world. Where did the passion for arbitrations come from?
It didn't come full born. I didn't wake up one day and say, I'm passionate about arbitration. It started in an odd sort of way. The South African Chamber of Business came to the bar, and I was then the chairman of the bar, with the proposal that the bar start taking an interest in arbitration, because the business community felt, as business communities have felt around the world, that they wanted a quicker method and a confidential method of resolving disputes. So they came to the bar, and my reaction, of course, was that this would be good for the bar. I had no idea really what it would involve, but the Chamber of Business had started their own arbitration center, and it wasn't working out as well as they had hoped, and they hoped the bar would take it over. So there we are. I had made the commitment to the business community. The bar was now involved in arbitration, and someone had to run it.
So this is way back when?
This is 1996. And it fell to me to guide it and to run it. And what I found was that we were pioneers in an area of the law that had been very poorly developed. We were pioneers in that area of the law where the law said, if you want to resolve your disputes outside of the courts and you want to do it confidentially, we will allow you to do it and we will recognize the consequences of that, but you're on your own. You don't want to do it through the courts, well, you and your adversary must work out for yourself how to do it.
This is what we call the ad hoc, am I correct?
Indeed, indeed. And the result was it was very difficult to establish a permanent structure. There was nothing there. And what we did was to begin the job of creating the structures that would enable parties who wanted to arbitrate to do so with confidence on the basis that the procedures and the skills in the implementation were available to them. And so the Arbitration Foundation was started as the first administering center of arbitration in South Africa.
Fantastic, fantastic. And I'm just going to touch on that point here, Michael. I want to read a quotation by Dullah Omar, the then minister who was responsible for justice. And this is what he said. He said, business has the right to know that there are legitimate mechanisms in place through which disputes may be resolved effectively, efficiently, speedily, and in the most economical way possible. AFSA will fill this void, and I wish it every success. Phenomenal. That's the dawn of democracy there.
He made that speech in June 1996, and it went far to inspire me. So much so that if you come into our reception today, you will see that speech mounted and set up in the reception. He went on to say, if I remember, and will provide an alternative access to justice. And that has always been, since he articulated that vision, the inspiration of AFSA. And to create that alternative access to justice, one needs the infrastructure. One needs to create the road which leads to that alternative access, and that has been the work of AFSA, and that is what has fascinated me over the years.
It's quite prophetic, so to speak, as if Michael was running with those words from Dullah Omar. In fact, these exact words were, any objective assessment of our complex, industrialized and commercial society indicates that even where an effective and efficient professional judicial system is in place, there is yet a need at every level of society for alternative dispute resolution mechanisms. Now, I want to pick up from that quote there. He says, at every level of society. How important do you think arbitrations and the systems of arbitrations are to the common man walking in the streets? I mean, usually we think of these huge conglomerates, these huge companies solving multi-million rand deals. But how do you think arbitrations can fit in to the person who's disputing an RDP house or something similar to that on a much smaller scale?
Arbitration is eternally, infinitely flexible and adaptable. It can be adapted to the littlest dispute. It can be adapted to the fight between huge corporations. And you can see that. You can see that adaptation in the way that labor has developed its own arbitration structures, in the way construction disputes have developed. But then you get closer to your example, the sectional title, where a homeowner is having a fight with the home next door or with the rules of that, and need some form of quick, fair resolution. Well, arbitration is adapted to that. So arbitration appears in many forms. Let me give you, although it's not your man in the street necessarily, example of that adaptability. You know that our law provides for business rescue. And you know that in business rescue, what you're trying to do is preserve jobs and trying to find a space for business to recover, yes, so that it continue in a solvent way. But business rescue means that the kinds of disputes and the kinds of grievances surface and tend to make it difficult for the rescue operation to be successful. Well, we have now formulated, and we think it's unique in the world, we have formulated an arbitral mechanism to deal with all business rescue disputes, whether it be the employees who face some form of retrenchment, or whether it be a creditor who claims to have a bigger claim than has been acknowledged by the practitioner. All this is capable of being resolved quickly. And quickly is the watchword of arbitration. So, yeah, it's adaptable, and the man in the street, just as the conglomerate, has a benefit from a good arbitration system.
Now, both of us are lawyers, and we have an understanding. I've had the benefit of sitting under some of your lectures. But can we distinguish a lawyer, judge, from an arbitrator? What would you say in a sentence or two?
A judge is trying to apply the law correctly on an appreciation of the facts which have been led in evidence, and his job is to return a judgment which is legally correct. An arbitrator is there to give the parties a fair hearing, and having done that, to produce a binding result. So that a judge must be legally correct, or if not, will face an appeal procedure. An arbitrator must give an award which is binding, whether it is legally correct or factually incorrect or not. His job is to provide, and her job is to provide, as arbitrator, a fair hearing to the parties and a quick and a fair result. So there's a distinction. Judges must be right, or they are subject to appeal. Arbitrators may be wrong, but they are final and binding, because the parties wanted no more than a quick hearing in which they put their case fairly, both of them, and then live with the result from a fair-minded, chosen arbitrator.
In fact, I'm going to quote something you said. You said in arbitration, we don't sell a legally correct point of view. Now, obviously, that is not to say arbitrators mustn't apply their mind, mustn't be fair, and use the common principles in a fair hearing.
But the point is, the parties contracted for a quick, fair outcome which would bind them. And provided it has been fair, the outcome does bind them. And they can't come along and say, well, if this was a court case, we would have been able to appeal. The judges love to say, and they often say, you chose arbitration, warts and all. And the reason people choose arbitration is because of its advantages, and key to that is speed.
Let's pick up on the controversy of arbitrations. And we know under the Arbitration Act, to review and set aside an award, it must be under the most extreme or gross irregularity. Don't you think that's a fair point of criticism, though, in the final and binding nature? Don't you think it's a double-edged sword? In one way, parties are receiving efficiency, and they're receiving the answer they were looking for, whether they like it or not. But on the other, courts are reluctant to look into arbitration awards.
Yes, and as far as I'm concerned, quite rightly. Courts must respect arbitration awards because they must respect the choice of the parties to have chosen that method of resolving their dispute. You go to business, or you go to anyone, and you say to them, look, I can give you a legally perfect result, but it'll take you 5 years. Or I can give you a fair result, and it will take you, let us say, 6 months. Which would you prefer? And I would think many people would say.
Absolutely. I mean, especially when you're dealing with large, complex, for example, in the construction industry, and every day you have workers on site, you have suppliers that need to be paid, subcontractors that need to be paid, and you've got timelines, deadlines, milestones to meet. You don't want to be appealing to the Supreme Court of Appeal or finding your way all the way to the Constitutional Court. You want something quick.
Yes, yes, indeed. And you choose construction, which is a very good example, but it's merely one of the examples. If you go to a small business, and a small business is having a dispute with a supplier, does the small business want to wait 6 years to have a result? Or does the small business want to say, let me state my grievance, let the other side state their grievance, and give us a fair decision in a couple of months?
I think you're touching on a very important point, and we have to come back and interview you on the characteristics and the traits of what an arbitrator, in fact the training, and we know AFSA is heavily involved in some of those things there. Now, one of the criticisms in the birthing of AFSA was that you are taking away work from us lawyers. You're making things very efficient, and we charge per hour.
Yeah.
What would your answer be to all those advocates who don't like you out there?
Well, I would say I've heard that complaint, not from advocates, but from judges.
Oh my.
The complaint from the judges has been, you're taking away the civil disputes of importance, and therefore you are not allowing the jurisprudence of South Africa to be developed to the full extent. Advocates and lawyers should have no complaint at all. They must simply ensure that they have the competence to participate in arbitrations. In all commercial arbitrations, the parties are asking for legal representation, and overwhelmingly they choose lawyers as arbitrators or retired judges. So no, the lawyers have no right to complain. As far as the judges are concerned, I think it's greatly exaggerated. If you look at our law reports, I don't think you will find...
They're running out of work. In fact, we know recently the caseloads can be quite staggering.
Yes, indeed. In fact, I really think the judges have a silent sigh of relief that their hugely burdensome caseloads are to some degree alleviated by arbitration. You know, we talk of arbitration cases in the hundreds, but the judges are talking of court cases in the hundreds of thousands, so that the burden on them is huge. But ultimately, it's the benefit of the public. And the public have two choices, as Dr. Dullah Omar was saying. And it's only to the good of the country and to the good of business and commerce that there is that choice.
Now let's touch a bit about the public, and you know we've heard this cry that the common man down the street can't afford Michael Kuper, certainly as a senior counsel. And I know you touched a bit on it, but where would you like to see arbitrations go in terms of settling the smallest of disputes? And would you say perhaps, I think you mentioned in one of your lectures that the khutlas and those chiefs in the old days, that was a form of arbitration. But where would you like to see this formal structure?
I would like to see arbitration more successfully employed in the huge number of cases falling into the small claim category. So you get the thousands and the hundreds of thousands of cases in the RAF. You get the cases and the hundreds of thousands of cases which are medical negligence cases. And those are just two examples of areas in our society where claims are being delayed and where the state entities are having trouble in somehow organizing themselves successfully to meet claims properly. I would very much want to see a form of arbitration which would be inexpensive and yet efficient, and which would allow young arbitrators, young lawyers who have a sense of wishing to act in the social good, giving of their time and their talent. I would like to see a buy-in from government into such a system. And I think it would be of great benefit. But that is outside of AFSA's ability to operate, other than to guide and to help. And it would give of its time, and it would give of its skills and experience in order to help the creation of those structures. If there was an opportunity to do that, we would, of course, be first in the queue to offer our services.
Well, you heard it straight from the pioneer of arbitrator. What a privilege it is to be interviewing him, that we need to get more arbitrators involved in medical negligence cases, as well as road accident cases that involve injuries and so forth, so forth. Can anybody become an arbitrator?
The parties can choose anyone they like to be their arbitrator, and one would think that their common sense would guide their choice. So far as AFSA is concerned, you would need to meet criteria to become an arbitrator. One of them is AFSA would insist that the aspirant arbitrator go through its own training, the training that AFSA offers, or equivalent training that AFSA recognizes. AFSA would also want its arbitrators to have some degree of experience. But eligibility to become a member of the panel would depend mainly on training.
All right, I think you've touched on a very important point for those that are aspiring to become arbitrators. AFSA provides the training, and AFSA provides the guidance on how to do that, if you're asking yourself that question. Let's jump straight into the next questions out here. What is the importance from an economic point of view? And we spoke about the social aspect of public interest. From an economic point of view, how can arbitrations help a country, a nation, grow? And I'm saying this because we know, and we'll touch a bit on that, about the affiliations and the partnerships that AFSA has with China and some of the BRICS nations.
Yes. I think you've got to start with the appreciation that trade and investment inevitably throws up disputes. And unless there is available a mechanism to resolve those disputes, which is trusted by the business communities and the investment communities, you don't have an essential oil to the smooth trade and the smooth investment processes. So if you look at cross-border investment and cross-border trade, which is the lifeblood of any country's development, you will find that the foreign party who looks to invest or to trade says to themselves, what will happen if there is a dispute? And if they feel that there is no reliable or credible mechanism in the target country to permit of a fair result if there is a dispute, then that is one of the features which will discourage them from making that investment or making that trade arrangement. It's not the only one, obviously, but it's one of many, and it's an important one. Yeah. So that I think you've got to look at arbitration as really the oil which smooths the wheels of trade and of industry. And once you see it in that context, then it becomes a matter of fundamental importance economically. And that applies within the country itself, and it applies in its relations cross-border. In South Africa today, if you open any newspaper, you read any article, you listen to any discussion, what is it about? It's about trade and fostering our industrial growth through trade, through investment, and how best to do that. Well, arbitration is one of the important factors which will help to direct trade and industry into a country.
So if I'm an investor, let's say from India, I would, and I've got $10 million, and I want to build a plant that manufactures microchips in Africa, for example, and we know that Africa at some times has been a bit slow, and we'll talk a bit about what your vision is for the SADC countries. I wouldn't go to a country where my investment would be at risk, where my accounts can be seized, where my operations can be stopped. I would need to go to a country where I know, even if I'm going against the government or high political figures, that there is a system, an institution or structure that is in place to protect those interests. And you've been involved in several cross-border.
Yep. And that's exactly right. You've summarized it perfectly. Just put in place the legal advisor of that Indian company. When the discussion is, should the investment be made there, in South Africa, or in Botswana, or in Angola, what the lawyer, or indeed, what the lawyer will say is, just a minute, chaps, what do we know about the legal system and legal rights in South Africa? Do we trust the investment to that country? And the question that is always asked is, what is the arbitration system and the arbitration reputation of that country? Because no foreign business anywhere in the world has as their trust or first prize fighting in a foreigner's court. That they don't want. What they want is a equal playing pitch, and they want some control over that process, and that means arbitration, and that means what is the quality of the arbitration center and the arbitration culture in that country.
So it's not a strange phenomenon for a country from North America and a country from Asia coming to AFSA to arbitrate.
No.
It's quite common.
But that couldn't happen until the government produced the legislation which allowed us to say to the world we have a legal structure that allows us to deal with international arbitrations on a credible basis. And that meant passing what is called the model law into our legal system. Once that was done, the doors opened dramatically to AFSA as an administering body. That happened at the end of 2017, and in the 5 years since, AFSA has become not only the top arbitration centre in Africa and acknowledged as such, but it has become accepted as a credible global arbitral institution.
That's phenomenal. It's quite an achievement from when you first heard those words of Dullah Omar, and you ran with them, you ran with the vision. But where would you like to see AFSA in terms of, or arbitrations generally, in terms of other African countries? As you're saying, it's an attraction to investment, jobs, infrastructure.
Yes. I believe that it would be wrong for South Africa, and it would be wrong for AFSA to restrict itself to South Africa. I believe we must see ourselves as an integral part of the SADC region. And in the SADC region, you have 16 countries, all of them trying to advance their economies, all of them trying to attract investment. And the answer then, so far as arbitration is concerned, I believe, is that they must come together in the form of an AFSA alliance, in which, whether the dispute is involved Angola or involves Mauritius or involves any of the countries of SADC, it is a standardized, harmonized international arbitration system that will be followed. And I want to see Southern Africa emerge as a region acknowledged globally as a safe place for investment and trade because of its credible arbitration system. And that, I believe, is AFSA's real final duty, to do what it has in South Africa for the region, in concert with the region, not as a domineering leader, but as the facilitator of a shared culture of arbitration.
Well, you've heard it wherever you're watching us from, different law society, different bars. This is a plea, really, from the pioneer of arbitrations here in South Africa and parts of Africa, saying to you, get your law societies involved, get your bars involved, find out how you can be affiliated with AFSA. Let's grow this system of arbitration, because ultimately it benefits all of us. If you were to be asked, what are some of the perceptions, negative perceptions of arbitrations you'd like to silence right now?
There is a continual complaint, well, it costs more. I now have to pay for the arbitrator. I didn't have to pay for the judge. I now have to pay for the arbitration venue room. I didn't have to pay for the courtroom. I now have to pay for the transcriber. I didn't have to pay for the transcriber when I went to court. And I now have to pay an additional amount to have AFSA administer. And all that's absolutely true. And if you say to business or anywhere else, well, does that mean it is too expensive? Business and everyone else would say to you, you're not understanding the dynamics. If it takes me 5 years to complete a matter, then even though the judge doesn't charge me and the courtroom doesn't charge me, the costs are huge and the time taken is crippling. If I go to arbitration, I will pay more in certain respects than I would otherwise, but I am getting a relatively speedy result. And that is what is cost effective. So don't come here and tell me what is the expense of arbitration. It is more cost effective than drawn out litigation is. And what's more, the parties have much of the control on costs. They can spin it out if they want and if the arbitrator allows them, but it's not cost effective to do that. There are multiple examples I can give you where parties who understand the arbitration dynamic can come out of arbitration at a far lesser cost than otherwise. There's another more dangerous criticism, more dangerous in the sense of more real, and that is if a party wishes to delay an arbitration process, the tactic, I don't use the term Stalingrad because I don't like using other people's terms, but you know what I mean.
I do, yes.
The tactic is to bring an application to court, either to stop the arbitration on some ground or to remove the arbitrator, as the case may be, because whether that has any chance of success or not, it may mean 6 months to a year's delay. And that undermines the reputation of arbitration. And I welcome and I appreciate the court's attitude, which is to mulct parties in punitive costs who are doing that. Nonetheless, in South Africa, it's done too much and too often. And that is a criticism that we must deal with.
Well, you can see the passion of arbitrations seeping through there. Michael Kuper almost getting angry at people employing tactics that are meant to delay arbitrations. And of course, the highlight of arbitration, the emphasis is that speed. That's very, very important for us to understand. Michael, this show is dedicated to lawyers. What would you say to young aspirant arbitrators out there?
I would say to all young lawyers, if you wish to have a commercial practice, you must become familiar with the arbitration concept. You must learn how it works, because it's going to be mainstream, and it is mainstream. You don't come across commercial contracts in the main which don't have an arbitration clause in them. So
some badly worded, but that's a story for another day.
Story for another day, but the trend is unstoppable and clear. So if you're going to practice commercially, you've got to learn about arbitration. And unfortunately, the universities who are teaching the full vista of the legal subjects aren't able necessarily to convey in their educational programs enough about arbitration, enough about mediation. So you must look for training. AFSA's training, I think, is, as you would expect me to say, and I mean it quite seriously, world class. You will not
We would expect nothing less.
You will not find arbitration training for South Africans or Southern Africans. You will not find it elsewhere in the world of that detail and that insight.
Now let me pick on you just a little bit there on that point. We do know that many arbitrations take place by using AFSA rules without your permission.
Yes.
What would you like to say to those?
I would like to say it's not right. It's not right from many points of view. Let me start this way. It's not right to the parties because they are told that this is an AFSA arbitration, but it is not. You see, what the parties, the pirates, do is they take the AFSA rules, which are administered rules, and they try and run an arbitration which is not administered under administered rules, which is rather like saying, I'm going to take you to hospital, but I'm not going to have doctors treat you. They're going to have to work it out for yourself, but I'm giving you a package where you will believe that you are getting the true goods. Well, you're not. And so it's a betrayal of the parties. Secondly, it puts our reputation in the hands of parties where we have no responsibility. You can imagine my constant annoyance when I read cases in the law reports about reviews involving AFSA, where AFSA had no part at all. The first we learn about it is where the thing predictably goes wrong because there is no administration, and it lands up in the courts. So, yes, you've spoiled my day by reminding me of this, and let's move on.
Right. So there's Michael Kuper, again speaking on behalf of AFSA's intellectual property. I don't think he's too keen on suing for copyright, but he may just do that eventually. Michael Kuper, thank you so much for joining us on the show.
Great.
I think the Jack Russells are barking and waiting for you to come back home. Until we meet again, thank you so much.
Thanks so much.